Hi, my name is Marco Jimenez Jr., and I'm here with my colleague Dan Landry. We are both third-year Juris Doctor candidates at New England Law Boston and are enrolled in Professor Teixeira D'Souza's family law class. As part of a class presentation, we have picked the important topic of how to obtain two types of protective orders in Massachusetts. The two types of protective orders include, number one, abuse prevention orders, commonly known as restraining orders, under Mass General Law, Chapter 209A, and number two, harassment prevention orders under Mass General Law, Chapter 258E. The information will be presented in the following order. I will first discuss abuse prevention orders under Massachusetts General Law, Chapter 209A, followed by Dan, who will explain harassment prevention orders under Chapter 258E. We will first explain the purpose of each order, followed by discussion of the governing law, an explanation of who can obtain each type of order, legal issues, and definitions involved in obtaining the order, and an explanation of how to fill out the forms required for obtaining each order. I hope this presentation is not only educational, but beneficial in the furtherance and protection of those seeking either type of order. If you have any questions, feel free to contact a free legal service provider or go online and visit www.masslegalhelp.com. Additional sources of information are also provided at the conclusion of the presentation. Disclaimer. This presentation is intended to be used strictly as an informational tool and for educational purposes. It should not, under any circumstance, be interpreted by anyone to be providing or offering to provide legal services, legal advice, or a legal opinion. The facts and circumstances of every situation are unique, and informational material such as that contained in the following presentation is never a substitute for legal advice from a licensed and experienced attorney. We do not accept any liability regarding the information in the presentation or liability as to the use of this information in any legal action that might have adverse effects on either party. Remember that obtaining either one of these orders could have adverse effects on the defendant. First, we will discuss abuse prevention orders under Mass General Law, Chapter 209A. The first question you may have is whether or not you're entitled to relief under 209A. Chapter 209A enables a family or household member suffering from attempted or actual physical harm, fear of imminent harm, and forced sexual relations to file a complaint for an abuse prevention order. 209A also defines who a family or household member is. You may fall into one of the categories listed below. If not, take a look at our section on harassment prevention orders under Mass General Law, Chapter 258E to see if you qualify. Considering whether or not a relationship was substantive, the court looks at the totality of the circumstances, focusing on the factors listed below. There are two important things to remember. Number one, the statute allows for a person to be in more than one substantive relationship at a time. And number two, grandparents of children whose parents are not married may also obtain an abuse prevention order against the parent who is not related. Here is a list of the 11 forms that can be used in applying for an abuse prevention order. Note that you do not have to fill out every single form in this list. Some forms are specific to particular circumstances. Next, we will discuss each form and its purpose and provide a link where each form can be found. Here is the complaint form. The complaint form is the most important form. The complaint form is important because it is what the judge will use to decide whether or not to issue an order. The second page of the complaint form is used only when the plaintiff has children under the age of 18. part of the complaint, you will need to fill out the affidavit, providing a detailed account of the history of the abuse for which you are seeking relief. On the defendant information form, the plaintiff will provide as much information about the defendant as possible. The police will use this information to find, serve, and restrict the defendant's use of firearms. Next, we turn to the plaintiff information form. The plaintiff information form requires the person seeking the order to provide both residential and workplace information that is deemed confidential, except as authorized. The request for access to plaintiff confidential information form is used when a defendant or other party moves to request access to plaintiff confidential information, which may only be released by court order. The judgment or order form is used by the presiding judge to record his disposition on the application for an abuse prevention order. The order form will provide the instructions of the order and any other restrictions on the plaintiff or defendant as necessary. A motion for impoundment is used when the plaintiff wishes to have confidential information impounded or not made available to public. If you have a current order from another jurisdiction, you must fill out the affidavit for filing out-of-state protective orders. You must file it with the Massachusetts court in order for it to have any sort of weight in Massachusetts. The plaintiff affidavit in support of request for a child support order is used when the plaintiff is seeking child support from the defendant. This usually occurs when the defendant is the father of the child or children and they are under the age of 18. The defendant's affidavit in support of request for child support order is similar to the prior form, but from the point of view of the defendant who is seeking child support from the plaintiff. The plaintiff's motion to modify or terminate abuse prevention order must be filled out by the plaintiff and presented to the court. The judge will then hear the motion and decide as to the best course. This is similar to the prior form, but also from the perspective of the defendant. If the defendant wishes to modify or terminate the abuse prevention order, this motion will need to be filed by the defendant, and a hearing on the motion will take place before the judge. This is the translation of affidavit. This form is to be used only when the affidavit attached to the complaint is transcribed by another person or if the affidavit is in a language other than English. Now that we've gone over each form, I will now show you how to fill out and file the complaint form as well as the affidavit in support. The Massachusetts Abuse Prevention Order complaint form. In Section A, you will check off the appropriate box for the court in which you are filing. Also, fill in the division of the court. For example, the Worcester Division of the Probate and Family Court. In Section B, the plaintiff is required to put down their name, while in Section C, the plaintiff or defendant must tell how old they are. Section D requires the plaintiff to disclose information on whether or not the defendant possesses weapons, while Section E requires historical information on any case where the plaintiff and defendant were involved. Section F requires the defendant's information and their sex, while Section G assesses the relationship between the plaintiff and defendant. Lastly, Section H asks if the plaintiff has children under the age of 18. If so, the plaintiff shall complete parts of page 2 of the complaint form accordingly. A asks the plaintiff to provide the type of relief the plaintiff is seeking from the court. Lastly, the plaintiff must sign and date the complaint form. Once page 1 of the complaint form is completed, proceed to filling out the affidavit in support of the order. First, you will provide a list of dates for each incident where the defendant attempted physical harm, caused imminent physical danger, forced sexual relations, or actually caused physical harm. Remember to be as detailed as possible in your affidavit. Lastly, the affidavit of support requires the plaintiff to sign under penalty and perjury. Therefore, it is imperative that the plaintiff only describe actual events and not lie on the affidavit. Remember to use the affidavit to sign the affidavit, and if the affidavit was transcribed or in a language other than English, you will have to attach the translation of affidavit form with the complaint and affidavit. Remember that additional forms may be necessary depending on factual circumstances.
When compared to harassment prevention orders, some believe that an abuse prevention order under 209A is easier to obtain because it often requires the person seeking protection, who's the plaintiff, to allege one single act that qualifies under that statute. It is important to remember that 209A orders are only available when the plaintiff and defendant have or have had one of the relationships that Marco previously discussed. As you will see, harassment protection orders under 258E are available to a wider range of people as they protect a person who is being harassed without any requirement of a special relationship between the person seeking protection and the defendant. At this point, you are likely wondering how a harassment prevention order can even help you. Like most people who are being bothered by someone, you have possibly tried already to avoid seeing the harasser in person, ignoring or blocking unwanted texts or calls from the person, or you may have even changed phone numbers or your address. If a judge does issue a harassment prevention order against the defendant, and that's the person bothering you, there are a range of conditions that the judge can impose. Although this list is not exclusive, it is common for a judge to order the defendant to refrain from abusing or harassing the plaintiff, the person seeking protection from the court, or refrain from having any contact with the plaintiff unless first authorized by the court, even contact that's through a third person or on the internet. When the plaintiff requests, it is also common for the judge to order the defendant to stay away from the plaintiff's home, work, or even a school that the plaintiff attends. Lastly, a judge may order the defendant to reimburse the plaintiff for money that the plaintiff has spent as a direct result of the defendant's harassment. As I mentioned earlier, a judge does not need to find that there is now, or has been in the past, a special relationship between the harassing party and the party that seeks protection. Even though harassment orders are most oftentimes sought by a person who personally knows or knows of the person doing the harassment, a harassment prevention order can be obtained against any person, even if a complete stranger you have never met or seen. But keep in mind the judge will still need to find that the defendant specifically directed the harassing conduct at the plaintiff. According to the law that determines whether or not a harassment prevention order will be issued, the judge must find that the plaintiff was subjected to harassment as defined by that statute. There are three distinct and separate ways that the plaintiff can prove harassment, which in turn allows the judge to issue the order against the defendant. Here, the word prove means that the judge must believe that it was more likely than not that the harassment occurred. And said another way, the judge must conclude that there is more than a 50% probability that the defendant harassed the plaintiff in the manner which the plaintiff claims. Under the first subsection on this slide, a plaintiff can prove harassment by claiming that on 3 or more separate occasions, 1. First, that the defendant's malicious actions were specifically directed at the plaintiff. Secondly, the defendant intended to cause the plaintiff fear, intimidation, abuse, or property damage. And third, the plaintiff actually did experience fear, intimidation, abuse, or damage to her property. Malicious here means that the defendant acted with revenge, cruelty, or hostility. To satisfy the third requirement, it is enough for the plaintiff to claim that, when taken together, the entire course of the defendant's separate actions caused fear, intimidation, or abuse. The second way a plaintiff can prove harassment to the judge, labeled 2A in the slide here, is by making a credible claim that the defendant's actions caused the plaintiff to involuntarily have any type of sexual relations with the defendant. However, This option is the least used by plaintiffs. This is because of the language regarding the specific proof required for this option and the fact that oftentimes the crimes listed in 2B overlap with the requirements of 2A but can be proven without showing force that is required by 2A. This next slide lists 12 separate and distinct crimes that also satisfy the definition of harassment under Chapter 258E. The crimes can be seen here. Now, it's important to note that the defendant does not need to have been convicted for the crime that the plaintiff alleges, or that he even could be convicted beyond a reasonable doubt. The plaintiff only needs to convince the judge that it is more likely than not that the defendant committed the sex offense listed here. Here's an overview of the different forms associated with harassment prevention orders under 258E. The first three are required by the plaintiff. The first, the complaint, is 3 pages in total, including the affidavit and the instructions. Next is the plaintiff confidential information form, followed by the defendant information form, and then less often used are the translation of affidavit form, the motion for impoundment form, and the affidavit for filing out-of-state protective order. These last 3 are only used when the circumstances call for them. Here we see the complaint form. As Marco mentioned when discussing the 209A abuse prevention orders, in Section A it is important to note the court where you will be filing your application for relief. And now note, if both the parties are under 17 years of age, the petition needs to be filed in the juvenile court, and that court uses a separate form, so it's important to obtain that form. You want to make sure that you fill out all of the information fully and accurately, as it will provide the judge with the appropriate basis to issue an order. This is the affidavit form, which is also a part of the complaint package. This is perhaps the most important form that you will file in relation to your petition. It tells the judge in your own words the reasons for which you are seeking protection against the harassment of the defendant. And now it is important to note here that the judge will use this affidavit as a basis for determining whether or not you have shown harassment as it is defined in that statute. These are instructions to the plaintiff, and this page is also included in the complaint package. You will want to read these in detail before you attempt to fill out the complaint form and the affidavit. The plaintiff confidential information form is used by the court to get certain identification information related to the plaintiff, such as the address, name, date of birth, and the plaintiff's workplace. This information will be kept confidential from the defendant and the public. Do note, however, that this information must necessarily be used by some court employees in the administration of their duties. You do have the option of filing a motion for impoundment, which we will see in a moment, to protect this information from view from even those employees. This is the defendant information form, and the plaintiff does want to take care on this form to make sure that the information is the most up-to-date, that the information is also complete and accurate so that the police may quickly and safely find the defendant and serve him with the order once obtained. The translation of affidavit form will be used in circumstances where the person seeking protection has a primary language other than English. The affidavit, which may be written in the foreign language of the plaintiff, will be translated on this form by somebody approved by the court to make that translation, and this should be included in the complaint package. The motion for impoundment form that we see here is the same form that Marco described when discussing its application to 209A Abuse Prevention Orders. Now, it is important to note with this form that the plaintiff needs to have a good reason why certain information will be impounded and therefore protected from the viewing of the public or, as I had mentioned, certain court employees that may view the information. And it's extremely important to know that just because the plaintiff prefers to not have this information revealed is not a sufficiently good reason for the court to order impoundment. This here is an affidavit for filing an out-of-state protective order. If a plaintiff has obtained a harassment prevention order or a no-contact order from another state or jurisdiction, and they want that order to be effective in the jurisdiction of Massachusetts, they need to file this form. To allow the police and courts in Massachusetts to be able to enforce the out-of-state no contact or harassment prevention order, this form must be filed with the court. Here are some additional sources of information regarding both 209A Abuse Prevention Orders and 258E Harassment Prevention Orders. We would like to thank you for taking the time to view our presentation, and we hope that the information has been helpful.